Court of India and a senior standing counsel at the Honorable High Court of Delhi. Sir contributed to the deliberations and advocacy to bring out legislations on domestic violence and sexual harassment, leading to enactment of Domestic Violence Act 2005 and POSH Act 2013. Sir's major areas of expertise include labor and employment laws, administration and public laws, and arbitration law. Sir has also contributed in writing papers for the Ministry of Labour, Government of India, ILO, and several other legal journals. Welcome, sir. May I please request Danix Probationer Shri Mukesh Dhakkar to welcome Mr. Sanjay Ghosh, sir. Next speaker is Mr. Naveed Ahmed, sir. Sir is a team leader, crime and punishment at Vidhi Center for Legal Policy. Sir is currently working on the issue of over-criminalization in Delhi, in India, and building a roadmap for decriminalization of minor offences, rationalization of punishments, and adoption of principle-based criminal law making. Sir has contributed in several publications on the subject of criminal law with a focus on penal provisions related to drug abuse and crimes against women. Sir has also been a critic of the new criminal law bills. We look forward to listening to your viewpoints, sir. Requesting Danix Probationer Shri Adesh Pasnotra to please welcome, sir. Next panelist is Senior Public Prosecutor Shri A.T. Ansari, sir. Sir holds the position of Senior Public Prosecutor at the Government of NCT of Delhi. In his long career spanning over 25 years, Sir has contributed a great deal in conducting prosecution of the most heinous and gruesome offences, including rape cases, as the first public prosecutor at the fast-track court. Sir was one of the lead public prosecutors who conducted the trial of Nirbhaya gang rape case and secured capital punishment for all the accused persons. Sir has been a special public prosecutor in several other sensitive and high-profile cases, such as Batla House encounter case, Ubhar Cinema tampering of evidence case, etc. We are proud to have such eminent personality on our panel. Requesting Danix Probationer Shri Kalyani Jagtap to please welcome Shri A.T. Ansari, sir. We are truly privileged to have such an experienced and diverse panel of speakers. I now request the chair of this panel to kindly take this forward and moderate the discussion.
Thank you so much. Am I audible? I think this is not working.
Hello, hello.
No issue, no issue.
Mic. Hello, hello. Can you hear me? No. Yeah, that's fine.
Good afternoon, everyone. Let me first congratulate UGCS for organizing such a wonderful and much needed conference on the 3 new criminal laws, and especially for 3 very important pillars of criminal justice system: judiciary, police, and prosecution. I'm also extremely delighted that I'm in the midst of such versatile panelists today, who not only represents some very important stakeholders in the system, but also are experts in their own rights in their respective fields. The panel today is certainly representative of, as I mentioned, some very important stakeholders. But I believe one of the most important stakeholders, and for that matter for every law, not only of these 3 laws, is the public. And this new law, BNS, BNSS or BSA, is a welcome step in this direction, And you all will agree that the endeavor by the legislature by drafting these laws is to ensure welfare of the citizenry at large. And these laws are much more public spirit. The IPC which we were having for so long and altered to our needs was in fact a colonial legacy, drafted with a different perspective. The BNS allows us to change that. The old criminal legislations were primarily designed to maintain order through punitive measures, often disregarding the socio-cultural realities of the Indian populace. These laws were primarily designed to subjugate and control rather than to uplift and rehabilitate, and were consequently misaligned with our notions of justice and humanity that we hold so dear to our hearts. It was primarily on account of discontent with the punitive trappings of the old laws that there has been a long-standing demand for a comprehensive overhaul of our criminal justice system. Before we further begin, on a lighter note, I may say, on the flip side, the introduction of these new laws, which, as we all know, retains almost 90 to 95% of the existing provisions, by primarily jumbling up the sections. My memory for the past 33 years in the legal field, and even for my 3 years of law school days, has gone for a 6. I do not know what is now 302 and what is now 420. Now it's difficult to call a person he is a 420. Yeah. So that is, and I believe it must be true for all of us. Now, originally we were assigned around 90 minutes, but Maheshji told me that it has been curtailed to 75 minutes. So, am I right, sir? So I think after making some initial comments, as you all, I would also like to hear our distinguished panelists. So, for 10 to 12 minutes, and thereafter we can have questions from the audience before we sum up the session. So, your approval for the timing?
Sir, if the speakers want, they can make it interactive also.
Yeah, certainly that is there.
They're all very learned audience, so they know the provision.
I was just asking about the outer limit. You are mentioning.
So at 1:30 we got to break for lunch, we can make it 1:40.
Yeah, no. We will stick to 1:30.
1:40.
Now, you all must have heard in various speeches and all this, and you might find it repetitive. But I would like to flag a few important aspects of BNS, which probably may guide today's discussion. As we all know, the earlier IPC contained 511 sections, whereas the BNS now contains 358 sections. It is not that all the remaining sections have been deleted or omitted, but an effort has been made to collate and organize various offences of different nature, different class. The definition sections under IPC, which were from section 6 to 52, have now been collated under section 2 of BNS. various offences relating to theft from 410 to 414 IPC have been collated now under section 317, and it is in fact primarily because of this rearrangement of sections and consolidation of sections. The critics say that it is nothing but old wine in a new bottle. However, I choose to say that old order change is yielding place to new. In all, about 44 sections have been deleted in BNS, such as reference to Queen, British India, though they were already repealed, but they were still mentioned over there, etc. Besides some important provisions, such as section 377, unnatural offences. While the amount of fine has been increased for certain offences, the period of imprisonment has been enhanced in about 33 sections. Mandatory minimum imprisonment has been now provided in about 20 sections. Around 28 to 30 new sections have been added, and some of the prominent offences which have now been specifically provided, I would like to mention, though time doesn't permit, so we can't go for each and every new addition. Section 48, relating to abatement outside India for offence in India. Person sitting in a court, and if he abates any act or offence in India, that is now made punishable. Section 69, relating to sexual intercourse by employing deceitful means, etc., and which also includes having sexual contact while making false promise to marry. We all have been reading such cases. So it has been distinctly provided for now. Section 95, relating to hiring, employing, or engaging a child to commit an offence. Section 1032, clause 2, relating to mob lynching. The word mob lynching is specifically not mentioned over there, but it specifically tackles the dead situation, which of late we have been seeing a number of cases that we have. That is murder by 5 or more persons on the ground of race, caste, community, sex, place of birth, language, personal belief, or other similar grounds, and for which each member of such group shall be punished with death or with imprisonment for life, and shall also be liable to fine. Section 106, clause 1, which is the replacement of section 304A, causing death by death or negligent death. It also now provides causing death by rash or negligent death by a medical professional while undertaking a medical procedure. Section 106, clause 2, though it has been put on hold, not yet notified, but it provides that if a death is caused by rash or negligent death, and the driver of the vehicle fails to report to the police or the magistrate, then he shall be liable to an enhanced degree of punishment up to 10 years. Now these are very important sections. Section 111 provides punishment for organized crime, and 112 provides for what shall be petty organized crimes. Section 113 defines what shall constitute to be a terrorist act. However, before I call upon the learned panelists to offer their comments and observations, I would say that there have been other certain welcome changes in the new laws, which are primarily on account of certain pronouncements by Honorable High Constitutional Courts of the land, and to a certain limited extent on account of changing nature of crimes being witnessed by us. I am deliberately saying that to some limited extent, because there are certain crucial new form of crimes, especially the cyber crimes, which have not been touched upon in the new law. efforts though certainly have been made to provide some kind of certainty to the laws. And I do believe that over a period of time, various aspects will be duly addressed by the constitutional courts in the cases which are bound to come up before that. The BNS has provided a uniform definition of child as being a person below the age of 18 years and has thereby done away with the use of the word minor and person below the age of 16 years or 12 years. The character of justice to be dispensed is also sought to be changed. A new form of punishment, that is community service, has also been introduced for certain petty offences, such as public servant unlawfully engaging in trade, non-appearance in response to a proclamation, petty theft or on return of theft money, misconduct in public by a drunken person, etc. And in all, community service has been provided as a form of punishment for 6 offences. Section 202, 209, 226, 303 clause 2, 355, 356 clause 2. A new separate offence for snatching, 304, has also been introduced. Certain offences have also been made gender neutral. The offences relating to assault or use of criminal force to women with intent to disown, section 76, and voyeurism, section 77, have been made gender neutral. Section 141, relating to importation of girl or boy from foreign country, has also been made gender neutral. However, I have certain concern about the form of punishment provided under BNS. Now, section 4 provides the kinds of punishment which under BNS. 4 small b provides for imprisonment for life as a form of punishment. And it appears that life imprisonment, as has also been, as you all must be aware, stated by the Supreme Court on quite a few occasions, means a sentence for the remainder of life. Subject, of course, to the power of remission to be exercised by the government. However, certain sections under BNS, such as section 64 clause 1, which provides punishment for rape, stating that the punishment may extend to imprisonment for life, but under section 64 clause 2, it states that in certain aggravated circumstances, the imprisonment shall be for the remainder of that person's natural life. Similarly, section 103 clause 1 provides life imprisonment for the offence of murder, but section 104 states that when a murder is committed by a life convict, the punishment with imprisonment for life shall be the remainder of that person's natural life. Does it mean that the power of remission of the government shall not be exercisable in such cases? I am certainly aware of certain pronouncements by Honorable Supreme Court, where it has been observed that life imprisonment means imprisonment for entire life, but certainly omission for life imprisonment for the remaining natural life as a form of punishment needs to be noted in section 4. Also, while some offences, as I earlier mentioned, have been made gender neutral, but for certain reasons which are not easily discernible, the rape laws under BNS have not been made gender neutral. In fact, just 2 days back, on the Delhi High Court in a PIL file related to omission of section 377, directly sent the government to consider this aspect, primarily considering that section 377 is no longer in the statute book, and there is no provision at present which may punish any sexual offence relating to rape. As regards the punishment of community service, I may state that though it is a very welcome change, but my concern is that it has been provided only for certain very minor offences, very minor aberrations. Firstly, it has also not been defined under BNS. Those explanation to section 23, BNSS says that community service shall mean the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. However, this explanation leaves the field wide open for judicial interpretation as to what could be the nature of community service. It would have been good if some illustrations at least could have been given to guide this nature of punishment. Moreover, had community service as a form of punishment been provided as an alternative to imposition of fine, or for certain small sentences, that it would have certainly led to decongestion of jails. A few days back I obtained data from the central jail. There are a large number of convicts lying over there who are there on account of non-payment of fine and for undergoing small period of imprisonment. And it is a very important, you people all must be aware about probation of offender. It says, section 12 says that if a person has been treated under section 3 and section 4 of probation of offender set, then the disqualification of conviction shall not be attached to that person. But for certain reasons, no such identical provision is there in BNS as regards community service. So, even if a person is sentenced to community service, the disqualification relating to conviction shall still be there with that person. Now, just finishing off, I got it swept for. Now the important where I would like to have use of, especially Madam Mr. Bhati and Sanjay Goshi. I'm just a minute. The important aspect of concern is deletion of section 124 is sedition. Section